The following is the first lecture for the Criminal Procedures course at Contra Costa College, Adjus 122. All rights are reserved, and copies of this audio or lecture material may not be distributed without the express written permission of Rick Ramos or Contra Costa College. The first lecture is on the fundamental concepts of law. What I expect students in this course to read one chapter per week and review the key terms in the textbook. This is to be done every week so that you understand the material, and the more that you listen to the recorded lectures, the better chance you have that the replication will lead to retention of information. A test on the text will be given every few weeks and before finals week. Listen to the lectures to understand the specific information that will be tested in any state police academy. What we're hoping to do is help you specifically in California with Learning Domain 15, which deals with laws of arrest. And the things that we want to make sure that you particularly learn about are detentions, the laws of arrest in California, booking procedures, pat searches, searches incident to arrest, and the accusatory process. First, we have an adversarial system in which the two sides, the prosecutor and defense, go at it in open court in front of a judge. And the terms that I want you to get right now are going to be adversarial system, proof beyond a reasonable doubt, and common law. Let's see if we can stick with those for right now. So again, prosecution defense have at it in court. Like they say, all's fair in love and war. Same thing in court. Anything that's relevant and legally collected can be used in court upon the decision of the judge. Each side has fair and equal access to the same resources and information because of a term called discovery, meaning that each side must show lists of witnesses, what those witnesses will talk about, and any information that's going to come into the courtroom. Secondly, we have to adhere to the idea that individuals are innocent until proven guilty. The notion that individuals are innocent until proven guilty might be more appropriate if we can think about the term proof beyond reasonable doubt. Now, proof beyond reasonable doubt, it means that there is no possible doubt in your mind that the person that you're dealing with is guilty of the crime they've been brought before the court for. Typically, we'll call the person after when they're on the street and we make an arrest, we refer to them as a suspect or suspected of a crime, so we call them a suspect. Once we bring them into the system and they're charged by the district attorney, they're considered a defendant. They're defending themselves. So one time I brought a number of students into a traffic court, and we later met with the judge in the judge's chambers, and the question I had for the judge was, how do you make these decisions regarding whether or not somebody's guilty or innocent? And the response from the judge was that in a situation where they listen to the information coming to them, and if he has a doubt in his mind, he immediately finds a person not guilty. If he believes that there's sufficient probable cause to show or evidence to show that the person committed the crime, then he finds them guilty. The next term we want to talk about is common law. Now, the law from the United States is derived from the British legal heritage called common law. It's a body of law that was not written but was evolved over time in Great Britain through customs, traditions, and court decisions rather than in statutes. Now, statutes are written law. So today our laws are written down in an array of books called codes. Typically, you might have in California about 12 different codes dealing with welfare and institution, education, the penal code, which is the one that we're most involved in using because it deals with crimes, the vehicle code, the administrative code, building codes, fire codes. There's a variety of things that are out there that we use. Nonetheless, the basis of our law today comes from common law. Now, not only is it the traditions of how laws are enacted, but also appellate court decisions or decisions that come from court decisions or judges, where judges are making decisions on the bench that affect the rights of citizens. And this is all basically considered common law. The highest law in the land is the U.S. Constitution. And the U.S. Constitution basically has how our government is structured. It has what's called the triology, or the legislative, judicial, executive branch. When we look at that, you have to the legislative branch is made up of those persons in the House and Senate that are elected by citizens of the United States who vote for them, and they're the ones that propose laws. They're the ones that are in power to put laws together. We then have whoever's the executive, the president, and at the state level, the governor, who would enact these laws. The judicial branch is responsible for reviewing those laws and determining whether or not they violate the Constitution. If they violate the Constitution, they're vague, they're ex post facto, and we'll talk about that stuff later. Then they'll say they're unconstitutional, and they'll basically overturn that law. They may send it back to Congress and have them revamp it a little bit. It is the highest law in the land, and when we look at preemption, and what we talk about there is what laws are the most important or hold the most water. The list, just so you can take out a piece of paper right here, you should write this down. Highest law in the land is U.S. Constitution. That's followed by federal law. After federal law would be state constitutions, and after that, state law, and down at the bottom of the bucket is local, county, and city ordinances. The executive branch is the president. It's also the governor, if it's at the state level of the constitutions. And the executive branch is responsible for the enforcement of the law. So police are really under they're under the executive portion of the Constitution, where we're supposed to be enforcing laws. The reason the Constitution is the ultimate source of our laws was summed up best in 1803 by Supreme Court Justice John Marshall, when he stated, "Any nation created by a document must be held to that document supreme," in a case called Mayberry versus Madison. And in that case, what he basically said was that the Supreme Court has a right to overturn cases that violate the Constitution. Now we're going to go into a history of just some things that I thought would be important for you to know, and how the development of our laws, how our procedures were created, really, the procedural aspect of the administration of justice system in the United States. The first thing you should know is the role of the sheriff. And what basically happened was that Alfred the Great takes control of Britain in 1870s, and he divides England into 52 political subdivisions known as shires. And he puts a knight in charge of each of those shires, and they're called reeves. Now, if you remember the shire, think about Robin Hood, right? And the shire. So that would be like what we would call a county nowadays. Now, eventually, the word shire reeve, which was the knight who was in charge of arresting criminals, bringing them to trial, disciplining them, it became sheriff. And so the duties included arresting criminals and holding them for trial, enforcing the king's law, and acting as judge and executioner. Early methods of trial included trial by ordeal. Now, here's the thought. Everyone believed that God would protect you. Okay, very religious. And so what happened was, matter of fact, it was believed that the king was chosen by God. God chose the king. And that so therefore, if you spoke against a king, you're speaking against God. That was called sedition. And if you were seditious, you could be put to death. It was also believed that if you were innocent, God would protect you. So these trials by ordeal would put you through a variety of different sorts of tortures, hold a hot pot or put your hands in boiling water, wrap the hands up, and after 3 days, if there's no scars or burns, that you're not guilty. But if your hands have burns or scars, then you're guilty. They had what was called compurgation. Now, compurgation, we still use that today. That's bringing character witnesses in front of you. That character witness would swear the innocence of the witness on their behalf, saying that, it's not within this person's character to commit these sorts of crimes. Atonement. There's basically a couple of different types of atonement. The first is just straight atonement, where the person pays restitution to the victim for whatever they did. The second is called blood atonement. Back in the days of Hammurabi, if you stab somebody, your punishment for being found guilty of that crime would be to be stabbed in the exact same place. Kind of interesting how they dealt with that. In 1066, William of Normandy conquers England, and he decides that what he's going to do is to control the citizens was to replace all the Anglo-Saxon reeves that Alfred had in there, the sheriffs, with his own Norman knights. And so he redistributed much of the land to his Norman knights, and consequential to his rule in general, the Norman reeves in particular were not well received. Obviously, you have the conquerors coming in, the people are not going to agree to work with them. People frequently hid men wanted by the sheriff and helped them to escape after arrest and before trial. And in an effort to counter these reactions by the citizens, William initiated a procedure called recognizance. It's a French word which requires the accused or his family or the townspeople to post something of value to gain the freedom of the accused pending trial. This became posting bail. That's how the history of bail came down. So the person would be released on recognizance. William also added trial by battle as a method of trial and settling disputes between individuals. However, the practice was limited to knights. Commoners continued to perform ordeals or pay atonement as the king's power grew, as did the church, and the church made increasing use of atonement as a preferred method for one making up violation of church laws and other sins. That became the standard. In 1116, before 1116, when someone committed a crime against you, the compensation would be paid to the victim. After 1116, and a lot of things that you'll find in history, is the kings get greedy, they want more and more money, and they change the laws to behoove themselves, to help themselves, line their own pockets, per se, to say the least. So in 1116, the victims received compensation from criminals for their acts. Now, King Henry establishes what he calls the king's peace, and he made the king the victim for all crimes, and he reaped the benefits of the convictions. Let's look at some of the definitions that Henry held at that time. Felonies were established a penalty of death, and the person was considered an outlaw. You could kill a felon on sight, and they use the term outlawry. You know, somebody who was an outlaw was outside the protection of the law, therefore they could be killed. Felonies included arson, robbery, false coinage, and also crimes of violence. The lower level crimes were called misdemeanors. All lesser crimes were called misdemeanors or misbehaviors, and the punishment was atonement or corporal punishment. Now let's look at the beginning historically of the court structure and how procedures emerge. The first thing to look at is the first grand jury. This was 12 knights from the shire and 4 from the village, and they would go around the countryside and listen to accusations of crimes and presented by the sheriff. The sheriff in each shire would basically have somebody arrested and would bring the information to them. They would determine probable cause to hold the person to answer. Now let's look at the term probable cause is used to describe the two aspects that the sheriff and now the prosecutor is required to prove. Number one, that a crime occurred, and number two, that the accused probably did it. We still use this term to this day. We still use the term probable cause. Now, the grand jury would decide whether or not the person was going to be held to answer based upon probable cause. They would indict the person, and the person would move forward to a second jury that would determine whether or not they committed the crime. The second jury was called the petite or trial jury. Citizens wanted more of a role in the justice system, and 12 citizens would hear cases and deliver verdicts about guilt or innocence. The interesting thing here is at the time, the grand jury decided whether or not to bring the person up for trial, and then the petite jury would deal with whether or not the person was guilty or innocent. There was a disconnect in a second group of individuals who had the responsibility to determine guilt or innocence, which is a good thing. As judges are making more and more decisions about future cases that are similar, these decisions began to be known as precedents. Judges would look back to see how a similar situation had been judged in the past and would follow the same long line of thinking. Today, when a court reviews a case and makes a decision, it can be used as an example for the deciding of future cases that are similar. This is called precedent. The use of presiding cases as a reference for deciding future cases is known by Latin phrase stare decisis, or the doctrines of precedent. Once an appellate court makes a case decision, it sets a precedent and establishes a procedural rule that the police, the prosecution, and other lower courts must follow. It becomes the example against which procedures in the future of similar cases are decided. Next, we want to look at the historical development of the law in 1215 AD. Richard the Lionhearted was a great king, and after he died, King John took over. And as a result, they had some problems. John was a really bad abuser of the other nobles, and the nobles didn't seem too concerned when the abuse rights of the commoner took place, but when John started to abuse the rights of the nobles, they responded quickly to protect their interests. What he did was he went back and he decided that if you violated the king's law, then the king could confiscate your lands and wealth. And then he came up with retroactive laws, which were called ex post facto laws. What this means is that if I tell you that it's against the law to wear a red tunic, okay, I've warned you, and so you don't wear the red tunic. I tell you that's against the law, I'm going to confiscate your lands. What he would do is say, I'm going to go back now, I'm going to say this is a law, and I'm going to go back, and over the last 10 years, all of you that wore red tunics are going to go to jail, and I'm going to take your lands. Well, the nobles didn't like that. They quickly moved to try to deal with him. And on June 15, 1215, they surrounded King John at a spot just north of Windsor Castle known as the Plains of Runnymede, placed their lances to his body, and offered him a deal he could not refuse, kind of like the Godfather, huh? They told John that if he signed the document they laid before him, they would not run him through with their lances, and John signed the document known as the Magna Carta, or the Great Charter, which listed 37 rights guaranteed to the citizens, primarily nobles and church officials. Most of the Magna Carta was copied from an earlier document of Henry I titled the Charter of Liberties, but the Magna Carta is a document numbered and cited as the main source of our Bill of Rights in the United States. One of the principal rights guaranteed in the Magna Carta stated that no free man shall be seized or imprisoned or deprived of his property without first having the case reviewed and judged by his peers. At that time, the guarantee simply referred to those citizens to be chosen from the community and form the grand jury and to review the evidence and determine if the case should go to trial. That initial guarantee was interpreted broadly to form the basis of the constitutional due process. Now, due process means there's a process that we go through to take somebody from arrest through conviction and actually sentencing. Everybody is guaranteed that due process, whatever it would be. So as a result of signing the Magna Carta, it guaranteed certain rights to the knights in England, and it brought forth a basis of our U.S. Constitution and the Bill of Rights, which came about in 1971. So the U.S. Constitution, Bill of Rights, I'm just going to talk briefly about those amendments that affect us and how we got them. Pretty much what was going on, James I was the King of England at the time that the colonists first showed up in the colonies in Massachusetts Bay, and as a result of the king didn't allow the colonists to have representation in the parliament. Anytime he wanted more money, he would raise taxes, and as a result, the colonists were really getting pretty upset about this. If they complained, they'd be stuck on a slow ship out to England. The king also had spies that would accuse people of crimes, and they would beat them into confessing, and then of course put them to death or put them on a ship, and they would be tried in England. They were looked at as second-class citizens. Those that started to organize and actually fight back, the king sent his army, and they would do what they call beletting soldiers. They'd stick soldiers in your house. They'd basically be with you 24/7, and so once we had the Declaration of Independence and we won the war for the freedom of the United States and formed the United States, people were a little bit worried about the original Constitution. They were kind of worried about who's this king, how much power can the government have, and really there were two groups that were fighting for control. Those groups were the Republicans and the Federalists. The Republicans were actually the liberals at the time. They believed that the government should run for the people, of the people, by the people. The Federalists believed that the rich should be in charge and that the government should run the people. So, after the Constitution was, 1777, we have the first writing of the Constitution. In 1791, which is, some years later, they send representatives of the colonies again to Philadelphia to write a amendment to the Bill of Rights. Now, it's interesting that an original draft of the Constitution was written by Benjamin Franklin sometime before the one that was written by Thomas Jefferson, and in that copy, it had a lot of this information in it. It just turned out that in negotiating with the Federalists and the Republicans, it didn't go through the muster and it didn't pass the first time through. So let's talk about the rights that directly affect us as police officers. Fourth Amendment, the right of people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the people or things to be seized. Later on, I'll be talking about search warrants. That's exactly what is cited in search warrants. Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous offense unless on a presentment and indictment of a grand jury. So we already talked about the fact that the first part of the process is that we're either going to have a grand jury indictment, or when you arrest somebody, they go before a judge, and a similar process takes place in California where a judge reviews it and determines if there's probable cause to hold a person. It also says that no person shall be subjected to the same offense to be twice in jeopardy of life or limb. And what that means, there's no double jeopardy. If you are found guilty or innocent of a crime, you cannot be retried. Nor shall be compelled in any criminal case to be a witness against himself, meaning that you can't be forced to confess. You can't use torture against suspects or defendants, nor be deprived of life, liberty, or property without due process of law. Remember, we talked about that process. So you can't be railroaded. You have to be afforded all of your rights, and that nothing can be taken from you for public use without just compensation, meaning that if someone comes and they want to take something, the government wants your property, they have to offer you a fair amount of money. The Sixth Amendment guarantees that in criminal prosecutions, all accused shall enjoy the right to a speedy and public trial by an impartial jury in the state and jurisdiction where the crime was committed, and they should be informed of the nature and cause of the accusation. And what that means is once somebody has been held to answer, the judge orders the district attorney to fill out what's called an information, which will list count 1, count 2, count 3, exactly what the person is being charged with, and we will talk about that more in future lectures. You have the right to question witnesses that are going to say bad things about you in court, things against your penal interest. And you also have the right to force witnesses who might be able to come to your aid that have relevant information about the case to show up into court and testify on your behalf and to tell the truth. And also, really important, to have counsel for the defense. Sixth Amendment also says that you have the right to counsel for the defense. Next, legal representation. That's really important. I just said that is Sixth Amendment. Eighth Amendment is no excessive bail should be required, nor excessive fines imposed, no cruel or unusual punishments shall be inflicted. And then the 14th Amendment, which came about sometime later in 1867, was added. And this says in Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereon of are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process, nor deny any person within its jurisdiction the equal protection of the laws. When you look at that, one of the things it does is it says you can't have slavery anymore. Number two, it says that was the section that was used by John F. Kennedy to allow African American students to attend racially segregated schools in Alabama. That stopped segregation. It should have stopped a lot earlier, but he brought that forward and used that to control that situation. The next thing we're going to do is we're going to talk about modern criminal law. When we think about modern criminal law, we look at a variety of things. The first thing is the person has to commit an act. We look at modern criminal law, it's got to be written, and it has to have some things in it in order for it to be legal. And this is in California. It has to have the act, which is also known as actus reus, and that's Latin for the act. Has to have the intent, and in Latin we use the term mens rea. And what that means is that the person was guilty. In other words, you have to, if you bump into somebody intentionally to push them into the street and hurt them, then you have mens rea or mens re. You're guilty of doing that. It's intentional. The intent is intentional, right? If you accidentally bump into somebody, that's an accident. And so it would not be a crime under California law. An example would be if I was working on a construction project and I'm 4 or 5 stories up and my hammer drops out of my tool belt and it falls down and it hits a coffee or hot dog vendor down on the street and kills them, that would be an accident. There's no intent for me to do that. Now, if I'm standing on the roof and I'm holding a box of hammers and I'm trying to drop these hammers down and hit the person, that's a whole different thing. That's a whole different thing. So the act and intent, it's also referred to as the corpus delicti, or the elements of the crime. The other thing is there has to be a concurrence between the act and the intent, which means if I have an altercation with somebody a year ago, and that has died down, I don't have any issues with them, and then I'm at driving down the road, lose control of my car and hit the person, or they're walking across the street and I don't see them and I hit them and kill them, you can't go back and use any threats I had given, like a year ago. There might be circumstantial evidence, but it certainly doesn't show that I had the intent to kill the person. There has to also be proof that there's a social harm to the person. In other words, if I swing at the person and I miss, or I'm not even close enough to touch them, you can't consider that a crime. Example, if I am throwing baseballs at you and you are 100 yards away from me, I probably can't even reach you, so there's no social harm. There's nothing that's going to happen to you. But if I take a stack of golf balls with a number 8 iron, which has about 150-yard loft, and I start hitting them at you, there's a possibility I could hit you. If I hit the person, the cause of the harm has to be from the act. Okay, if I do something from you, it has to be directly related to my act. There's that concurrence between act and intent. And the last thing that has to be codified in the law is that there's a punishment following the conviction. So the things that you got to look at is there's going to be an act, there's going to be an intent, it's going to tell you to do something or not do something, and there's going to be a punishment that follows. The next thing we're going to look at is the degrees of crimes and look at the ones that are the most serious and the ones that are not as serious. The first one is going to be felonies. Now, the way that the classification of crimes in California stem from the punishment assigned. So, for a crime to be a felony, the punishment would have to be death, imprisonment in state or federal prison for more than a year, removal from office, or disqualification from office. Check yourself. Any criminal statute by law must describe the action required, prohibited, and must have a punishment attached. We can list the elements in orders as follows. Should have the act or actus reus, should have the intent, should have the law prohibiting the act. There's got to be a concurrence between the act and the intent. There's got to be social harm. There's got to be an act caused by the harm, and there's got to be a punishment that follows. All right? An example would be entering a building with intent to commit a theft or any other felony is burglary. That's a felony, which is punishable by more than a year in state prison. So let's look at what I want you to be able to understand is if I have you go to a penal code and you pull out the penal code and you look at the definition of a crime and you look at the punishment, I need you to be able to really quickly decide whether it's a felony or misdemeanor, because in later training that we're going to have in this class, you have got to make a decision if it's a felony or misdemeanor, and at that point you determine whether or not you're going to make an arrest. So if the penalty is 16, 18, or 24 months in state prison, would you classify the crime that you looked up as a felony? And the answer is yes, it's a felony. Now let's look at the definition of a misdemeanor. Misdemeanor is any crime where the punishment is imprisonment for less than 1 year or a fine. So, petty theft is punishable by 60 days in county jail. Therefore, petty theft is a misdemeanor. Next thing we're going to look at is the definition of an infraction. Now, infraction only carries a punishment of a fine. You have to pay some moolah out, pay the man. So, stop sign violation is $207. Therefore, it's a misdemeanor. The next term is wobbler. The penalty can be interpreted as either a felony or a misdemeanor. In PC 261.5, statutory rape, it carries a punishment of 6 months, 18 months, or 24 months. But because it carries a punishment that can be interpreted as both either a misdemeanor or a felony, then it's considered a wobbler. And the district attorney is going to make the ultimate decision as to what's going to be charged. Now, side note, write this down. We always consider wobblers as felonies because under the power of arrest statutes in California, you have much more power to make an arrest when it is a felony versus a misdemeanor. So that's something to really remember. We're going to also look at the classification of crimes. We have what's called mala in se crimes and mala prohibita. Now you can read in the book about these really quickly, but basically here's what's going on. We have consensus, or we all agree that there are certain crimes that are bad in themselves. Those are murder, rape, and robbery. But we don't agree that there are certain crimes that we don't think should be crimes. Those are considered mala prohibita crimes. So mala in se, we all agree on. Mala prohibita come from individuals who are going to cater to special interest or personal beliefs. They have the power. You elected them into office, and they have the power to decide what new crimes will be. Examples of mala prohibita crimes would include smoking, drugs, gambling, fireworks, large parties that are loud where people complain, right? Next thing we want to talk about is parties to a crime. Who can be charged with a crime? The first category is called a principal. A principal is anyone who aids or abets in the commission of a crime. So let's break it down. John wants to rob a liquor store. He goes to Billy and says, man, I need to rob this liquor store. I got to get some money because I owe somebody some money. They're going to hurt me. Billy says, well, let me talk to Tom because Tom has a gun I can get for you. So he goes to Tom and says, hey, can I borrow your gun? I'm going to go to the range and practice shooting. Tom says, sure. And he gives him, Joe, the gun, and Billy also lends him a car. He actually helps him steal a car, gives him that car. So Joe goes back to the liquor store, commits the robbery. In this case, Billy aided him by giving him the gun and giving him the car. Tom, on the other hand, doesn't know anything about the crime, so therefore he can't be charged with anything, right? He wasn't aware of it, so therefore he's not, doesn't have any criminal liability in this case. So principals, anyone that aids and abets, so it could be a crime partner, it could be somebody that's supporting them in any way, giving them codes for alarms, anything like that. The next category is an accessory. So the first thing you got to learn, write this one down on accessories, is that accessories only apply to felonies. If it's not a felony, a person can't be an accessory. Example, My little brother steals some beer from the local liquor store, runs to my house to hide. The cops knock on the door. Police let me in. I say he's not here. He ends up jumping out the back window because he's scared. They catch him. They can't hit me with being an accessory. They could hit me with other things, but I can't be an accessory because it's only a misdemeanor. But if it's a felony, the thought is this: somebody commits a felony, you're not allowed to assist them in trying to escape prosecution. Things that would make you an accessory to a felony would include providing money, a place to hide, airline tickets, giving the person a false alibi. Any of those things would be considered a violation and make you an accessory. Okay, get out a piece of paper. We want to test your knowledge right now and see if you can identify the correct match up the crime to the punishment. You're going to determine whether or not something is a felony, a misdemeanor, or a wobbler. So let's take a look at these. So take a piece of paper. Number 1, write down 250. Number 2, 22 months in state prison. Number 3, 6 months in county jail. Number 4, 10 to life in federal prison. Number 5, 6, 12, or 18 months in county jail, in prison or jail. Number 6, removal from elected position or office. Now I'm going to give you about 15 seconds to write whether it's an M, an F, or a W, misdemeanor, felony, or wobbler. And I'm going to give you, or actually an infraction too. So infraction, misdemeanor, felony, wobbler. Any of those things will work. Number 1, $250. Number 2, 22 months in state prison. Number 3, 6 months in county jail. Number 4, 10 to life in federal prison. Number 5, 6, 12, or 18 months in prison or jail. Number 6, removal from elected office. Let's see if you got these right. So number 1, $250 is an infraction. Hopefully you got that. If you did, yay. Number 2, 22 months in state prison is a felony. Number 3, 6 months in county jail is a misdemeanor. Number 4, 10 to life in federal prison is a felony. Number 5, 6 months, 12 months, or 18 months in prison or jail is a wobbler. Number 6, removal from elected position is a felony. Hope you got those right. Hopefully you got at least 4 of them right. If not, back up and listen to this part of the lecture again. Next, we want to talk about the court structure. And basically, there's 2 types of courts. First of all, we have what's called a dual court system. The first court system is based around appeals, and they are the courts of appeal and the U.S. Supreme Court, U.S. District Court of Appeals, California Supreme Court, and California District Court of Appeals. The next area is trial courts, and trial courts include the federal trial court and the superior court trial court at the state level. They handle all criminal cases, civil cases over $5,000, arraignments, preliminary hearings, juvenile court, traffic court, probate court, mental commitments, and small claims up to $7,000. Now, I've tried to give you kind of a diagram of what we have currently in Contra Costa County. So our Superior Court is in Martinez. It handles the most serious criminal matters simply because of its strategic location. You got the senior magistrates there. You also have, as part of the Superior Court, the juvenile court. Those judges are pretty much specially trained to handle that. And then in the outlying areas in Richmond, Concord, Walnut Creek, and Pittsburgh, you have individual, what used to be municipal courts. They're now also superior courts, but they handle pretty much preliminary hearings and some jury trials. At the state appellate court level, let's say you get convicted in one of our courts and you want to fight it, then what you're going to do is look at going to California District Court of Appeals, Department 1 in San Francisco, which is in our jurisdiction here in the Bay Area, and they would look at the case to determine whether or not you have any merit to an appeal. You want to complain that you weren't treated correctly. And from there, it can go to the California Supreme Court, which has one Chief Justice, 6 Associate Justices. They're located in Sacramento. Now, on the federal side, they have a similar court system. You have U.S. district courts here on the right. They handle criminal and civil trial courts. This is where the FBI, DEA, and other federal law enforcement will take you into court to try you for crimes. There's 93 districts in 50 states and Puerto Rico. Now, above that is the U.S. Court of Appeal. There's 12 districts or 12 circuits. California's in the Ninth Circuits. Pretty much everything west the Mississippi, including like Denver and Utah and Montana and Nevada and Arizona and New Mexico and California and Oregon and Washington and Hawaii and Guam. That's kind of it. Pretty big. And from there, you would go to the Supreme Court of the United States if you had any additional problems. So what's the difference between the two courts? Well, in trial courts, they determine what we call the question of fact. Did the defendant commit the crime? And in the appellate court, they determine whether or not there was any legal error, any procedural error, or if the defendant's rights were violated. Let's cover some other terms. Enhancements. Enhancements are additional penalties that are attached to crimes to deter career criminals' behavior that might include gangs, use of weapons, prior felony convictions, or someone who provides somebody with a weapon to commit a felony. Let's look at types of law. First, you have substantive law. This is the body of law that defines crime and punishment. This is what's written in the Penal Code, Health and Safety Code, Vehicle Code, Business Profession Code, Fish and Game Code. It tells you what to do or not to do and commands you to obey the law. Procedural law, on the other hand, has nothing to do with regulating the behavior of citizens. It's a body of law that lays out the step-by-step procedures that must be followed by peace officers, court personnel, correctional officers, and other officials in processing people through the system. So procedural law has to be followed by the court system. It's enforced by the judges most of the time. Statutory law is written law that comes through the legislature, either state or the Senate or Assembly at a state level, or Congress and legislature at the federal level. It's written. Case law is a body of law that results from court cases actually created by judges. If a person is arrested, tried, and convicted of a crime, either during or after this process, the person or their attorney that believes that they have been denied some constitutional right or protection along the way appeals the case to some higher court, either within the state or federal system. Judges in the higher court review the records and read and listen to arguments by the attorneys and to decide who is right in that case. Most of the time, the decisions that were made before will be used to clarify whether or not the person has a complaint on their case or a good appeal. And what attorneys are going to do are find like cases and use them to justify their arguments. And this is what we call case law. They will use case law. The other thing we need to talk about really briefly is civil law. What I've done is I basically put a chart up here, a table, to try to show you the difference between criminal law and civil law. Let's look at it by determining the victim and punishment. In a criminal case, the victim is a state or the people of that state. So in cases in California, it would be, people of the state of California versus Jones. The punishment would be death, fine, imprisonment or removal from public office. We've already gone over this as far as misdemeanors and felonies. In a civil case, though, and one of the things you got to look at, in a civil case, the victim is the individual. And they're going after restitution to bring them back to where they were before they were wronged. Criminal law deals with the relationship of individuals and their government. Civil law deals with the relationship of the two individuals together. In a criminal case, somebody goes to jail. In a civil case, you sue them, you try to get money out of them to recoup your losses or damages. The next term we need to talk about is a social contract. and it refers to a theory that attempts to explain or describe the origin and maintenance of organized society and the legal relationships of the citizens and their government. In its simplest terms, the theory holds that the state and its government and laws was created and is maintained through the mutual agreement entered in by all citizens and the state as a way of having social order, protection, and freedom. At one end of the balancing point is absolute security, safety, and social order, and at the other end is the absolute personal freedom. In other words, the state wants you to be free, the state wants you to enjoy yourself, but you can't tread on other people's rights when you do that. There's always this balancing point that we have, and that changes as time goes by, and it's changed and reflected by the new people that we elect into the legislature to create new laws. The citizens recognize that at times there's a conflict between the freedom and maintaining of the social order and safety, and they can't have both complete freedom and safety because they are sometimes in conflict with each other. So there's got to be a balance to it. We don't want to have absolute social order because it would really limit our freedom. However, absolute freedom would lead to anarchy and complete absence of social order and security, meaning people would come around and take your TV and, hit your dog and, break your windows and do whatever the heck they want to do. So there's kind of a balancing point that we have to use. The Patriot Act of 2001 and now extended 2015 is an idea that we need more protection. We need to have less probable cause for officers to be able to surveil possible terrorists. And there's a balancing point here we have to deal with. It suspends constitutional protection, allows more surveillance with less probable cause, and there is some public worry about intrusion. The balancing point is that we need this law to protect ourselves from terrorist attacks. Now, something that's noteworthy is that Benjamin Franklin said many years ago, those that shall give up liberty for security shall have neither. So we have to kind of be careful with this and make sure that it's not abused, that individual officers abuse what we're actually trying to accomplish with this law. Next thing I want to talk about is degrees of proof. And degrees of proof, the first one is a hunch. What does it mean when you have a hunch? When you are walking down the street and you see somebody and they look like they're doing something. They look like they're kind of guilty. You don't know what it is that they're doing exactly, but they are doing something. And we call it a gut feeling, right? Well, unfortunately, that doesn't mean very much in the area of law enforcement. You got to have higher levels than that. And the bottom line level that you would use is what's called reasonable suspicion. So let's look at a situation and determine whether or not we have reasonable suspicion. You're responding to a silent burglary alarm, and as you're responding to the silent burglary alarm, you realize that you see coming out of the back of a building one of your local burglars that you've arrested numerous times for burglary. Now, what you have to determine is a crime occurred. Yeah, you believe a crime's occurred. You got an alarm going off. You have a suspect leaving the area that has priors for burglary. You would have reasonable suspicion to stop the person. When the burglar, let's call him Freddie Kelly, when Freddie sees you, his eyes get real big. You see a sign of surprise. He turns around and you hear him say, "Oh shit, the cops." So you hear him say this. Now, this is what we would call a consciousness of guilt. It leads you to believe he has a consciousness of guilt. This allows you to detain him. So it's at night. You have a burglar, prior felon, maybe he's even on probation or parole, has a search clause, but you are going to pat search him for weapons. So you're going to pat search him, and you feel a hard object in his right front waistband. You pull it out, and it's a small crowbar. It has about a 3-inch wide pry area on the end of it. Your partner goes to the point of entry on the burglary, establishes that yes, there is a burglary and there's a pry mark there. And he describes the pry mark as being about 3 inches wide. Now, this takes us to the next level. We had reasonable suspicion to detain him, pat search him. Now we have probable cause to arrest him. He was leaving the area. He has a tool on him that has a similar mark that's left, the pry mark. Now, through the scientific method, we may be able to verify or not verify that that was a tool used, but this is the minimum that you would need for probable cause to arrest. Remember, we said that a crime occurred. That's number one. Number two, the person that you're arresting probably did it. And it sounds like we have this and that this has worked. This has worked out. The next level is a preponderance of evidence. In civil cases, basically the preponderance of evidence is the minimal amount of evidence that you need to find somebody liable in a civil case. In other words, you have somebody who's driving down the street at a normal speed, and you have another person who has a stop sign that controls the intersection, and that person ends up in the intersection in an accident. Because it's a controlled intersection and you can show the direction of travel, there's a preponderance of evidence that the person who's guilty of the stop sign violation committed the accident or was negligent, and their negligence led to the accident. Hopefully that's clear. Next level is clear and convincing evidence. This is evidence that would basically prove to most people that a violation occurred. At one point in my lifetime, I sat on the Richmond Police Commission in California, Richmond, California, where I was responsible for looking at cases and determining if officers were guilty of misconduct. And in these cases, we had to have a level of clear and convincing evidence to find the officer guilty of misconduct if they or sustain complaints against them. Now, in my mind, what that meant was if you just had an officer and you had someone else there and there's no other evidence, there's no other witness statements, I could not find conclusively that an officer was guilty of anything. If I had an independent witness separate from that instant case who was telling me that the officer did this, that, the other, that would lead me to believe that they had committed the violation, then I felt that I would have clear and convincing evidence to make that decision. The highest level is proof beyond reasonable doubt. And again, this goes back to our original thinking that individuals are innocent until proven guilty. And so the maximum degree of proof that humans are capable of having is called proof beyond reasonable doubt. This means that no matter what, you feel that the person did it, that there's no doubt in your mind that they're guilty of having committed the crime. Additional terms that I want to make sure that you know include ex post facto retroactive laws. Remember we talked about earlier that King John, before the Magna Carta, put together a law that went back in time, and it was called a retroactive law. It goes back in time and is a disadvantage for the accused because they didn't have a chance to uphold to the law. It punishes someone for something they did in the past. Jurisdiction and venue refers to the authority of some agent or agency to act in some capacity. Often the authority is limited by some political boundary. For instance, a city police officer has jurisdiction or authority within their city limits. The sheriff has authority within the county, and state peace officers have the power to act statewide. Venue is really considered the county in which a crime occurred and where a jury is going to be drawn from. We already talked about corpus delicti, and that deals with two elements. It deals with act and intent as it refers to the harm or loss to a victim, or harm or loss that was caused by some criminal means. And independent state grounds is basically describes a legal concept by which a state, through its legislature, can enact laws that provide greater protection or greater procedural protection for people accused of crimes than that required by the Constitution, but they cannot enact laws that would provide less protection for citizens. You need to check in the course management software to determine whether or not I have followed up with a current event assignment. Will probably be in a discussion area or in your homework area. And what I want you to show me is that you can identify felonies or misdemeanors or wobblers. So I want you to find a local newspaper, and I want you can do it on the internet, or you can do it using a regular newspaper, and I want you to capture an article and tell me if a felony took place or a misdemeanor took place or a wobbler took place. Keep the article for a discussion assignment later in this class, and we'll refer back to it. But what you want to do is try to find one. If you could find a wobbler, that would be great. That's probably going to be the harder one to find. Your weekly reading assignments are really important. It's important that you also download this lecture, put it on a MP3 player or on a disc that you can listen in your car, so that the hope is that the more times you listen to it, the more you'll pick up. The vocabulary that we're talking about here is really necessary to your function in the field later on in a career in law enforcement, probation, parole. Again, on vocabulary, review the vocabulary at the beginning of the chapters or end of the chapters of the textbook. Make sure you can spell and define each of the new terms. And this is really going to help you later on when we're doing testing. Well, that's it for this lecture. This is the end of Lecture 1 for Adjus 122, Criminal Procedures. And make sure that you stay up with your homework and your exam schedule, and I'll get back to you soon with lecture number 2.